Good afternoon. This is Lenny the Lawyer Live, and our topic for today is bankruptcy. But before we get started, click on the subscribe button and the top of the bell icon so you always get notification of future videos that I make. We're going to give you an overview of the differences between Chapter 7 and Chapter 13 in this video. And if you want more detailed information, make sure to leave me a comment below and we'll be happy to answer your questions privately. Now, this video is for informational purposes only. This is not legal advice, and hopefully this will provide some entertainment to you as well. Although, don't worry, I'm not giving up my day job. I'm not going to become a coffee spokesman, and I'm not going to become a comic. I'm still going to be practicing law. So let's go over the basics of what a Chapter 7 is and what a Chapter 13 is. Both are your rights under federal law. The Chapter 7 bankruptcy is commonly known as liquidation bankruptcy, but that's not really true. You're not liquidating anything other than your dischargeable debts. You will be able to protect against creditors' claims, with rare exceptions, any kind of pension or retirement account that you may have. You will be able to stop wage garnishments immediately. And in fact, if you've had a wage garnishment, we can probably recover up to 3 months of the amount that's been garnished prior to filing the bankruptcy. In addition to that, nobody can sue you as a result of Section 362 of the United States Bankruptcy Code unless they get the court's permission to do so. Now, you must list all your income and expenses, assets and liabilities in the bankruptcy questionnaire that my firm or another firm will give to you. In my office, we download all your creditors from your 3-bureau credit report, so you don't have to write all those out. All you have to write out are those creditors that are not likely to report to the credit bureaus, such as doctors, plumbers, painters, other assorted service providers. In addition to this, you will not be able to use your credit cards. All your credit cards are lost. However, from the time you file till the time you get your discharge in bankruptcy, usually 4 to 6 months, you'll be able, after your discharge, to rebuild your credit. And I'll tell you about that in another video. But for now, Chapter 7 is your way out of financial devastation. You wipe out credit card debt, medical bills. Student loans are not currently dischargeable in bankruptcy, but the courts are leaning more and more towards allowing at least a partial discharge of student loans in bankruptcy. However, that's beyond the scope of this video. But for now, let's just say certain private student loans that have been given by dubious educational institutions that have either been shut down by state or federal authorities, those loans you may be able to discharge in bankruptcy. But we can't get into any specifics in this video. Chapter 13 bankruptcy is more complicated. The Chapter 13 bankruptcy is where you're using the bankruptcy court to protect your house or other major assets. You'll be paying your creditors a percentage of the amount you owe based on the amount of equity in your house. Also, if you're behind on your mortgage, Chapter 13 and the bankruptcy court are now your best friend. Why? Because if you need a mortgage loan modification, when you seek one through the bankruptcy court, the lenders can't play the same games they do when you seek one either through state court or directly with a lender. It's important to realize the following. When you seek a mortgage loan modification through the bankruptcy court, a motion is made to get you admitted to the bankruptcy court's mortgage modification program. When you're admitted to that program, you will fill out certain forms and provide certain documentation to explain your hardship. And if you're approved for a trial modification, you will be making 3 to 6 payments before you get approved for a permanent mortgage loan modification. Once you're approved for a permanent mortgage loan modification, you will find that you have a 40-year mortgage, most likely, at whatever prevailing interest rates are at the time. And depending upon the percentage that you're paying to your creditors, you may either stay in bankruptcy for the full 5 years or you may be able to emerge from bankruptcy. Either way, at the end of your bankruptcy, I'll provide guidance as to how you can rebuild your credit. Now, with the mortgage loan modification through the bankruptcy court, all the documents are submitted electronically through a portal. And in that, and they're timestamped, so the lenders can't conveniently lose things. And if the lenders do things that are so egregious, we have the option as bankruptcy attorneys to make a motion before the bankruptcy court to seek to either force the lender's attorneys to comply or, in certain circumstances, to have them held in contempt. But either way, bankruptcy is your right under federal law. And if you're a religious person, it's even referred to in the Bible. So there's no reason not to use bankruptcy if it's going to benefit you and you've done everything in a proper legal fashion. It's not going to help you with fraud. And we don't recommend that you do anything fraudulently ever. If you're approved for the mortgage loan modification, you will first make 3 to 6 trial payments. After that, you will be put on a permanent mortgage loan modification. Most likely, that will be a 40-year mortgage. Now, a lot of people think that they have a right to have their principal reduced. And while it does happen, I tell all my clients, don't expect it. Can it happen? Yes. Is it likely to happen? Probably not. But if it does happen, treat it as a gift. Don't expect it. Also, if you go to an attorney and they guarantee that yes, you're going to get a modification, yes, you're going to get a certain rate, you're going to get this, you're going to get that, there are no guarantees in life. The only guarantee I'm aware of in life is that it ends with death. And there are no guarantees in law or litigation. However, if you choose to meet with me, I can tell you based on my experience what I expect will happen in your situation. Bankruptcy is a very complex thing. There are state rules, there are federal rules, there are local rules of procedure, there's case law, there's rules of evidence. This is not something you can do on your own. And remember, in New Jersey, in New York, and in many other states, only attorneys are licensed to practice law, and only attorneys are the people you should seek to help you out with bankruptcy or any other legal problem. In future videos, we'll talk more about bankruptcy, the mortgage loan modification process, and what the upcoming eventual end to the mortgage moratorium means to you. Thank you for tuning in and have a great weekend, and look forward to our next video, which you'll probably see on the following Sunday. This is Lenny the Lawyer.